Okay, we're live a little early today. I had the schedule for 7, but a lot of stuff was going on, and actually, I was actually going to do this at 5, and I kind of forgot till Jared reminded me. We are actually going to do a part 1 on this channel, and then do a part 2 on Jared's channel for his Veteran Stock Weekly, which I think is going to work out really well, because the stuff I want to talk about and the stuff he wants to talk about are related, but I think that he's going to look at it from a very different perspective than me, in a good way, by the way. So I'm going to be sending everybody over to his channel after this. Anyways, I have the power couple. I have the king and queen both in here, Cheshire and 82 Productions.
Hey, we're going full on royalty tonight. That's just that's what this topic calls for.
Does it require the what do they call the royal council? What do they call it? The not the royal we, but they have it. They call it something in Britain. I can't remember. It's not the royal we, but it's the countess, the council, the I don't remember. I'm not British.
The syndicate?
No, it's not a syndicate.
No. That's something else completely. We'll talk about that later.
It's like the royal countenance or the royal court. That's what it is. The royal court. That's what I was thinking.
I was going to call it the ruling court because, well, why not? Because let's be honest. In all of the bullshit that has been going on lately, who are the ones that have been continuously correct on what's taken place?
So far, we've been batting exceptionally well. I mean, we can't plan on everything, but everything I've said so far has been the God honest truth, and we're going to be talking about a couple different things. We only have about an hour, so the couple things I want to talk about. I was going to actually have this titled something different. I did, and I changed it because people had brought some of these to my attention. But one of the questions I asked on Twitter was very simple, and it's a generic question. Do you think Kyle's going to go to jail? 200 people have actually already answered that question, believe it or not. 200 people plus, and it's extremely close, well within a margin of error. I mean, it's basically statistical insignificance difference at this point. Out of the 204 respondents, 47 said yes, 52.9 or 53% said no. Now, I worded this in a very specific way, right? It's a general question, and I was asking about people's belief, right? What they think about it, not knowledge, nothing like that. Just, what do you think of it? Now, I'm going to answer the question. I'm going to have you guys answer the question. Then we're going to actually talk about what was actually filed and what had actually been people being extremely misled about. Personally, I don't think he's going to go to jail for a couple different reasons. Do I think he has a high probability? I think there's a high probability the judge is willing to throw him in jail. Yes, that's I think is absolutely the case.
Definitely.
Do I think that his lawyer will probably convince him just in order to stay out of jail? I think that's probably a little bit higher threshold. So I'm going to go right now that, by the way, saying no doesn't mean that he's not going to jail. It's either that or agnostic, right? So I'm agnostic on at this point. I don't have a position either way, but I do lean a little bit more toward yes. But since I don't have a position on it, I'm going to go with no. What do you say, Chesh?
But it's not definitive, is what you're saying.
Oh yeah, well, nothing ever. I mean, we're not prognosticators, right? We can't predict the future. I'm only going by a bunch of variables. There's only 2 things that can keep him out of jail. This is from the judge. Again, we talk about facts on this channel. You talk about facts on your channel. Unlike other channels, they try to spin. I'm not interested in spin. I'm interested in what is in fact has been submitted. What does the court has said? The court has said there's 2 things he can do. That's it. 1, he can obey the court order. 2, show reasons that he didn't need to obey the court order. That's it. Those are the only 2 things the judge has told him. And he said it was up to incarceration, right? So what do you think? Do you think Kyle's going to end up in jail? Jared?
Well, I'll let my lady go first.
Aw, you're so chivalrous. By the way, that's microsexism.
Yeah, fuck that. Sorry, if being a decent human being in giving way to someone else makes me a sexist, well, then I got something you can choke on.
Welcome to the 2020, man. Now he's just harassing her. All right, go ahead, Chess. What do you think?
I think that he is petty and stubborn enough that, because at first we were like, oh, there's no way, but he's so emboldened by the people he's got around him right now, and he's so like set in what he's doing. I wouldn't be surprised if he just did it out of spite.
And I thought about that, but here's what I've noticed, and I'm sorry, but I do know Kyle, I think, better than anybody out there because I dealt the most dealings with him. Kyle puts on a facade when he's in public. Kyle puts on a facade of bravado that does not exist. He is actually very, very, very different in real life. And I think he's just feigning all this. I think he's putting forth this, oh, you know, Steve's did this and this and this, and I'm confident bullshit. He's scared shitless right now. I have no doubt in my mind. I mean, his lawyer has told him, I could almost guarantee that his lawyer has somewhere in writing, you are basically going against counsel, but if you do this, we have to do this, and this. But his lawyer, in no uncertain terms, this was asked by the judge. The judge had asked the lawyer, does your client understand the gravity of the situation? She said yes. She has made him aware of it. So, you know, there's no way that he had. I think that reality is going to hit him, and it's going to be a lot different than just this false bravado he's putting on for a show for these people that still think that he's somehow now turned over a new leaf and he's not lying like he has been for the last year.
Yeah, and I've been keeping an eye on the chat, and I do have to agree with a couple of the comments that I've seen out there. Is Kyle deserving of incarceration, even if it is a short bit?
Yes.
Yes. Do I see it actually taking place immediately? I'm leaning towards no as well, in the hope that he pulls his head out of his ass.
Yeah, but see, this is the way it works in North Carolina. I have OPT lawyer in the live chat, so he can confirm or deny this. But again, we like to have legal expertise here. But I've done some due diligence, which is more than I've seen from most. I've asked people that, okay, if you could quote me that, that Kyle has this, and this, what citations are you using? They never do it right. They never cite it right, and they misunderstand what was actually being talked about in the case every single time. But in the North Carolina, and this is probably true for any state, I don't know why it's be specific to North Carolina, but the compelling for a defendant to do something by the court can use up to incarceration. It's not supposed to be punitive. Now, from what I've read, there's always a punitive aspect of it, but it's not meant to be punitive. It's meant to be compulsory to have somebody do something, because that's one of the things that the court is able to use as a method of compliance. If the person goes to jail on a contempt charge, all they have to do to get out of it is just fix the contempt. Comply. That's it. That is literally all they have to do.
There's something else, though. There's a decent chance that he could end up going to jail for something else.
And that was another wrinkle to this. And so there was a question, not exactly worded as a question, but I will take it as one out of charity, that what are the actual hearings that are currently scheduled and laid out about? The first one is addressing the motion to set aside that has been amended but not amended and then countered.
That is correct.
That is the next one coming up, correct?
Yeah, and let me kind of clarify, because there was a little bit of misinformation out there, not from our side clearly, but it was the misinformation put out by Kyle and friends, I guess you can say. When Kyle had actually said that my lawyer had argued that we should do the contempt hearing first and then do the motion to set aside. That is absolutely true. My lawyer did do that. But like usual, Kyle and friends don't tell people the whole story. The whole story was, my lawyer did argue that because he wanted relief, but recognized that, legally speaking, to what's called judicial expediency, it is better to have the motion to set aside first. And that was when the judge said the reason why he wanted the motion to set aside first done is because that could be done remotely, just with the lawyers. The contempt charge he doesn't want to do remotely. He wants to see Kyle in person.
Why is that, Steve?
His words were basically, he wants him to be in person because he, quote, may not be going home that night.
Correct.
Okay, so that's from the judge. Now, again, if I had a judge telling me that, I would be concerned. People could spin it all the way they want, but this is something that Kyle is well aware of. This is why he even said, yes, the judge wants to see me in person. So my argument is pretty simple. Why would a judge who wants to set something aside be, so open to telling a defendant's lawyer, hey, tell your client that they better understand the gravity of the situation because, I can use up to incarceration to make him comply, and I want to see him in person. Right? By the way, hi,
Right.
Roof.
Hello.
Boy, you're
Hello.
getting dragged a little bit too. I think it's kind of hilarious how they're
it's
coming
fun.
after you, man.
I've been asking for it the last few days.
Yeah, but I loved how you shut them down because okay. Here I have all the court cases up. I think I'm all. I have literally each one tapped. I've read it, pretty much the gist of all of them. And you ask a great question, Ruhif. Same question I've asked people. Can you name a case where the defendant has received the papers and then it got set aside under some kind of non-excusable neglect? Because one of the things that his lawyer can argue is called excusable neglect, and that's part of Rule 60. Okay, that would be something along the lines of you didn't get the papers because you were sick, or you got the papers because you were in the hospital. Something that's excusable beyond your control. She doesn't argue any of that.
Extenuating circumstances for the layperson.
Correct. She doesn't argue that.
I don't think anyone really understands our argument. Like, our argument is that we have complied with Rule 4. We have the presumption of proper service.
Correct.
It's up to Kyle and his lawyer to rebut that presumption. And from all the case law, you rebut it by, claiming that Kyle's mum was not his agent, or claiming that you didn't get the papers because of X, Y, and Z.
Right, and that's what I wanted to bring up. In every case that I've read, okay, matter of fact, the ones that she even cited, most of those weren't certified mail. Okay, so with Rule 4, it wasn't certified mail. It was service by publication, no relevancy. The person didn't get the papers, which is, again, no relevancy. But if the person does get the papers, there's a couple different ways you can rebut it. One, you can show that the person was not an agent. That's really hard because in every case that I've seen, the only time they try to rebut the person was not an agent that can sign for the documentation is when they did not receive the papers. Because when they receive the papers, it's automatically presumed in North Carolina, since they've got the papers, that person was an agent because they got the papers. I mean, does it make sense?
Exactly. And there are cases where they couldn't even identify the agent. It's just a signature on a piece of paper, and they go, "Who the hell is that?"
It didn't matter though. That's what's funny. That's still it's assumed a service and still presumed to be an agent. That's what I'm saying. Yep. I challenge people. Can you find me a court case? And by the way, please leave them in the comments. I have the court cases up here, so I'm familiar with them, or in the live chat. Show me a case where the person received the papers and then argued that the person wasn't allowed to sign. It has never been the case where that has been overturned. The only time it has ever been an issue that I've seen was one person argued that his 15-year-old son was not old enough to receive the papers. He was not of age. What?
There was a 15-year-old daughter that was ruled suitable age and discretion.
And that was a son.
Oh, okay.
Yeah, it was a son. And they at least from what I remember. But I've been reading a lot of these things, so it doesn't matter. It was a 15-year-old child. They deemed that was suitable age, and so. Yeah. So the certain conditions have to be met as per Rule 4. A certified mail is no longer restricted mail. I know a couple people had been saying, "Oh, well, it had to be restricted mail." Though that was changed, I believe, in 2001.
No, actually, 1980 and 81. 2001 was when they brought in the designated delivery service of like FedEx and UPS and other private companies.
Okay, so that was
there's actually a case.
The non-postal service ones.
Yeah, there's a case that was started in 1979, but ruled upon in 1984 by the appeals court, where they had to use the 1979 restricted delivery clause. So, delivery to the addressee only. But right, it was changed
no longer
after the case was started.
Right. So why? So
now,
go ahead. No, go ahead. Well, I got to do
something. Oh, sorry. And Fender v. Deaton. So Fender v. Deaton is where they actually claimed that it wasn't. They said that it was a requirement for restricted delivery, even though that was changed, I think it was 15, 20 years before.
Yeah,
so that was one of the reasons why the trial
here.
court fucked up in Fender v. Deaton.
But it's weird. I actually have Fender v. Deaton, and that doesn't bode well for them if you actually read the whole thing.
No, Key West Coder just hit me up on Twitter saying that so in response to my challenge, name a case where the presumption was given to the plaintiff, and it was overturned for some other reason apart from I didn't get the papers.
Yeah, but
And he goes, the trial court did that. And I'm like, the fucking trial court was wrong. That's why I lost an appeal.
Right. The trial court was erred. The appellate court overturned it because the appellate court said it was his wife that received the papers in the business office, right? And they were trying to say, well, she wasn't authorized to receive his mail. And they're like, well, why?
Bull.
Yeah, it was, and that's what the appellate court said. They said no, she was authorized to because she received them and he got the service. And so the trial court erred by saying that it was improper. The appellate court reversed it by saying it was proper.
Correct.
So how does that help their case? Again,
I was stunned. He goes, the trial court held that it was improper service, and I'm like, the trial court was wrong.
That's why they have the appellate court's case. This is what I'm saying. I don't think they read any of this stuff. I really don't think they do. I actually read them.
Or they read it enough until they find something that they can latch onto that confirms with their bias.
Yeah,
they got to that point, and then, hey, stop, great. Never mind the reams of further information about the case, where they would have seen that the appellate court was like, no. The lower court screwed up on this. The service was actually correct. See, that's the thing, people. If you're going to read citations like this for relevance sake in that manner, you gotta read all of it.
Yeah, well, it's so funny because his lawyer quoted a few things. Like she quoted a state, the TLV Darby, and only put a part of it, right? Didn't have the whole quote.
Massive quote mine.
Massive quote mine. Matter of fact, there's a couple things. Did you actually read that one too? Because there's other things in there that were epic.
I've read every single citation that she has quoted, Scotty Forbes Lee, and they are none of them are relevant.
I know, that's
none
what
of them
saying.
are relevant.
In Darby, it actually says a party moving to set aside judgment under subdivision B1, which is what they're kind of going for, must show not only mistake, inadvertent surprise, or excusable neglect, but also the existence of meritorious defense. What is her meritorious defense here? They're arguing literally that he just didn't live there, which is not a meritorious defense, nor does it have any relevancy. I have found no case law that it mattered whether he lives there or not if he got the papers. None.
I've got to read something about this home address thing. All right. Defendants have argued a convoluted, non-obvious construction of North Carolina Rule 4J1C, contending that service by certified mail is allowable only at a person's home, not at his or her office. And this is the key line. The language of the rule makes no reference to home or office that is relevant here. It requires simply that a complaint sent by certified mail be addressed to the party to be served and delivering to the addressee only. And the word only has been dropped off.
Yeah, because it's no longer only. That has been changed. It is no longer only. When they say to the addressee, it just means that it has to be sent to the usual place of abode. I have the Rule 4 process here. And what they're actually talking about is the what's considered to be a natural person. That's actually what it's defining, because in one of the cases, they had served on a city, and the city could not be construed as a natural person.
Yeah, they were stricter. There's that Johnson v. City of Raleigh, North Carolina.
Ari Raleigh, I believe it was, yeah. Johnson City, Raleigh, yeah.
Yep.
Yeah, so it's interesting you bring up that whole home address thing. For everyone out there on the panel and in the chat, when you move, where are two key places that you update your address?
With the
Postal
post
Service and the DMV or RMV, depending on your locale.
Well,
of what Kyle's lawyer submitted, why was there nothing from either of those agencies to show that the address was updated with them?
Because I don't think it. I think she knows.
Still accepts mail at his mother's house,
and that's the key thing. I noticed there was a couple things that were conspicuously missing from her motion. And again, this is one of those situations that I can almost guarantee she was probably hired initially to do the contempt thing. When she started reading all this stuff, she was like, "Oh, there's a little more, more to this, and you kind of screwed up from the beginning here. How can I make the most of a bad situation?" And that's what a lawyer does. I mean, I don't fault her for anything that she's doing. She's done nothing unethical, nothing wrong.
Oh, I do. I fault her for not actually understanding our argument and
No,
just
no,
responding
I think
to
she
something
does.
that's not
I'm
our
gonna-
argument.
I'm going to give her the benefit of the doubt. I'm going to give the benefit of the doubt that I think she does, but a lawyer has to lawyer. Okay.
Valid. Yeah.
Okay. But here's where I think that there's just no excuse now, and because she didn't include certain things, and I think she did it for a reason, knowing that she didn't have cause to. One, she had nothing to show excusable neglect per rule 60. She cites Rule 60 in her brief. She cites Rule 55, which is about court proceedings, and she cites Rule 60, which is excusable neglect, but doesn't show any types of excusable neglect. I don't understand why she did that. Two, she doesn't show any argument that his mom was not authorized to sign. There's no contention there, which, by the way, wouldn't matter anyways for the fact that she signed and he got the papers. It would only matter that if he didn't get the papers, that's when you would invoke Rule 60 and say, hey, I didn't get the papers. It messed up over Rule 4, which is how to serve somebody, and therefore this person signed for it, but I didn't get the papers. Then you have some kind of actual maybe excusable neglect. Maybe.
Yeah, no, there are different rules there between service on a natural person and service on a corporation. If you send papers to the registered agent of a corporation and they get it, but they don't pass it on, that is still proper service without actual notice of the defendant getting it.
Yeah, but for a corporation, but for business, that happened with Reese, and that fact, well, there was with Reese. It was a tire store or tire company, and there was an accident that happened, and the litigant was suing all the people involved with the company, including the company itself. And by the way, this was actually read by a couple other people the other day on YouTube, and they seemed to miss.
Yeah, and they
butchered it. They butchered it.
Yes.
No way. Because the plaintiff have argued that Reese had notification of the service. He didn't get the papers. They just conspicuously neglected to mention that part. Reese didn't get the papers. She was arguing that the corporation or the business got the papers, and all those other people got service back, right? But she never got anything back from Reese. And the court was said that's not a valid, there's no merit to her argument there. And they were right. That's what had no merit. He didn't get the papers. Yeah,
because she, in the plaintiff's appeal, it was basically starts with, even if the service was defective, they still had actual notice. And everyone is claiming that that's our argument, that our service was defective. Our service was not defective. We got the presumption of proper service.
Right. There is nothing there is nothing defective about our service. And the funniest thing is again, people aren't understanding. Service is presumed once it goes in the mailbox and a certified mail and there's a receipt attached. All that is by Rule 4. That is all was done perfectly. There's nothing against Rule 4 that was any kind of procedural error of any kind.
And that's what Scotty Forbes Lee, half of her citations are actual defects in service where they did not follow Rule 4, so
Correct.
They didn't send it certified mail.
One of them was a regular mail, right? That doesn't. Yeah. Yep. Another one, it never got. There was no signature receipt, which again required by Rule 4. So all these things that were technical errors, and by the way, in a lot of these times, again, in every case there was a technical error, the person didn't get the papers.
That's also true, but a defect in service will render service improper.
Yeah, but it depends on the type of defect. One, if it was, for example, let's assume he got the papers. Let's see, it wasn't. They didn't get certified mail sent back. They didn't get a receipt. That would be a defect. They have to actually file a copy of the signature with the court. That is per the rule. That would be a defect in service.
Yep.
Yeah, and
in the case that they did get the papers, but still ruled improper service. Yeah.
And that's the thing here is the argument is from this side of it is like it's been stated. Let's make it very clear. The argument is that the service was proper as per North Carolina law, and this is the cherry on top. Kyle does not know how to shut his mouth.
Correct.
And because of that, it was recorded on multiple instances papers that I was served.
Yeah,
Yes.
and that's funny.
There is no doubt that he got them.
If he never admitted he got the papers and he never sent that letter to the court, he probably could have got away with lying to the court, maybe a little bit more.
Oh yeah, if he was silent throughout the whole thing, like everyone's saying, oh, it doesn't matter what he says afterwards.
Oh yes,
absolutely it does.
Absolutely it does.
Of course it does.
Yeah, no, I mean those two things really just because his lawyer won't lie for him. That's what I'm saying. She has to lawyer, but she cannot lie for him. She cannot argue that he didn't get the papers. That was the most conspicuous things, because in order to show excusable neglect, the main thing is you didn't get the papers. That is in everything that she cited. Go read what she wrote. In every case, they didn't get the papers but one, and that was again deemed proper service because a 15-year-old had signed for it. So it still was proper service. Not once I have not seen a single case where the person received the papers that it was overturned.
Yeah, where a presumption was overturned. Yeah,
presumption overturned, because then they have to show that they weren't so properly. We have nothing. Yeah. We don't have to show anything.
OPT lawyer says Kyle responding to the court's partial judgment before filing is a massive problem for him. Yes and no. There's a question of whether that is a general appearance before the court and whether that stops him from then pleading a motion or putting forward a motion of improper service. My opinion is that a court will see someone pro se and just go, look, it's a fairly technical way to squash a motion of improper service.
Yeah, I disagree.
I think the court will just say, look, that's a bit of a technicality and let him off on that. So
yeah, well, the problem is that it is still evidence, right? So even it is, yes. That's not going away. That letter's fraudulent. That is not going away. That you can't just say, hey, look, we take this back. There's no do-overs with that.
Yeah, there's no mulligans on that.
There's no mulligans.
But well, and here's my question. I can't remember off the top of my head. What was the gap in time between that initial letter and then his initial attempt at the filing?
It's only like 2 days.
Yeah, a couple days. But see, our first correspondence was our demand letter that we actually sent on July 16th, supposedly the day that he moved. By the way, again, they have to actually show.
Supposedly.
Yeah, they actually have to show that moving makes a difference. Even if we grant that he moved, which I don't think was necessarily the case, they have to show.
Should we tell everyone we have secret evidence that he didn't?
You know what? I do have some stuff that I think would be of interest to people, but we don't need it. It doesn't matter. But go ahead.
Yeah.
Go ahead.
But it will come out. It will come
out in limited discovery. Yeah. Chash, what were you trying to say?
Is asking if Steve wins, won't Kyle still have his 50% stake in non sequitur show?
No.
So
at that point, the business is non-solvent. Yeah.
It's mostly so that would be like, hey, you attack this person, now marry them because there's a kid.
Yeah.
No. Crime that's been committed here. They're not going to force them to work together or still give the guy money.
Yeah,
it's just not.
Here again, people seem to just kind of sweep this in the rug. Kyle was found liable for fraud. He took $60,000 of the business's money. That's an evidence. He's admitted to this. I mean, it's not just by default, which is, again, doesn't matter, still liable. He has said the company earned $60,000, which I believe is going to be more than that, but we don't have the books.
It's crossed off of Mike and Ike's.
And yet he didn't give me my share of that, right? I mean, there's just no justification for that. Does anybody think that a court's going to go, oh yeah, we think that he should be able to keep that money? No, it doesn't work that way. I mean, there's no outcome where he's not going to get a judgment against him.
Yeah,
no.
And these invoices made up after the fact and without any agreement at all. That's
that goes into the question.
Pattern of behavior.
That goes into the question: is he going to go to jail?
Behavior, and it will have an adverse inference against him.
Well, and doesn't that also fall under? I believe the terminology is fruit of the poisonous tree. You cannot profit from a crime.
Well, no, there's a little bit difference there. He can profit. I mean, he's entitled to half the proceeds. Okay.
What if you served the papers to Iraq?
Oh, there was a case where they sent it to South Africa, and they still was right service.
I was going to bring that one up. Yeah, well, to be fair, that's because the person on the receiving end in South Africa was the sibling of the defendant.
Yeah. Let me read this super chat real quick.
If you serve papers to when we say the address doesn't matter, when we say that doesn't matter, people go, oh, you could send it to your mate's house and your mate could sign for it and you'd have proper service. Obviously not. Under the law, if that happened and you sent it to some random address, yes, we would still have the presumption of proper service, but you could easily rebut it. The defendant could easily rebut it, saying, that is not my address. I did not get the papers because that's not my
address.
Now, what
if they did, Ruf? Let's say that you sent it to some mate's house and you happen to be over there and your mate gives him the papers. Then what?
Hang on, no, we're talking about I'm the plaintiff and I sent it as a joke to my friend's house.
You sent it to place X, and that person is not really
not related at all.
Not related. The defendant barely ever goes there, but the defendant happens to go there by chance and he gets the papers.
Oh,
Icarus makes a good point.
I would say you'd have a good argument for not an agent in that respect.
Icarus makes a good point in the chat. He says, people, it was never 50-50. Same people. It's 50-50. Kyle keeps half of
it. That's a cracker, yeah.
Yeah.
That is a cracker.
Yeah, that's true. Icarus is right. Go to Unicorn 5 says, I think they think since Kyle got papers improperly, did not. The case along with all established facts to be thrown out, laughing my ass off. Yeah, that doesn't work that way. Let me make it very clear that the complaint has already been there. Okay. If for some reason that there wasn't proper service, which again, there's not. I can tell you right now, it's not going to happen. But let's say hypothetically, because we could do that here, hypothetically that was, they just go back to the complaint and everything that's already been given for discovery is still there. That letter's still there. It doesn't go anywhere. And you basically have them reserved and we ask for a summary judgment, more than likely. I mean, because everything is already on the table. He's already admitted that, it's 50-50. He's already admitted that he took $60,000. He didn't pay me. There's no way he's going to get out of that. So it doesn't behoove him by any means, except that it is pretty well par for the course when people get a default judgment that they try to have it vacated. It's most people generally do that. So there's nothing new by this, right? Let me read this real quick. This was a state of Teal and Darby that she had actually quoted in her motion.
Sorry.
But they say here, a defendant must give its litigation matters that level of attention which one gives important business matters. The primary duty of attending to litigation remains with the defendant. In other words, a defendant must give its litigation matters that level of attention one gives important business matters. You can't just get the papers and not respond.
Even if he get the papers, he would, because he submitted something and he clearly knew what was going on. Particularly,
this is the one. This is the one where Kyle's lawyer invokes two cases, I think, where defaults were set aside when there was some, basically an accident. So this one defendant was, actively involved in the case, and he told his lawyer all his responses in good time. And the lawyer for some reason just didn't file it, and it was defaulted.
Right.
And like Kyle's lawyer is depending on this case, as that's
which has nothing to do with our case. The lawyer in this case didn't file properly. It didn't file in time. That's what it was.
Yeah,
and the court said, "Hey, a minute. Even though the lawyer didn't file in time, you still have an obligation as a defendant to know what the hell's going on."
In this one, they said that they shouldn't impute the incompetence of the lawyer to the defendant.
You're right.
They overturned
You're right. You're right. Until they actually said the lawyer screwed up, but we shouldn't impart that on the defendant. You're right. But the defendant still should have a duty to know about his business affairs. But they did agree that the lawyer's
that's
mistake.
Obviously not what happened here, because Kyle knew about it, dicked around for 5 months, so he's not going to get that benefit of the doubt. Like I said, every single case law, every single precedent that Scotty Forbes Lee cited was just not relevant. Literally zero of them.
Did we ever figure out about what counts and what doesn't count as perjury in whether or not he knew about service and whether or not filing one thing and knowing the passwords being incorrect and giving them out before even giving them the court, et cetera, et cetera.
I don't think there's much to be done on that. That's going to go into the contempt hearing. I mean, all that. One, he was supposed to give that to the lawyer, not to the. Yeah.
Just not doing what the court order is. That's going out of your way to cause intentional damage to plaintiff during that particular.
that's probably see, but all that kind of goes into the why the judge I think can use will use up to incarceration, right? Because he has seen the gamesmanship, right? Normally it would just be like, hey, you know what?
Yeah.
Let's fix this, right? Now I got some lawyers, let's make it happen. But he's seen a willful non-compliance. I mean, Kyle's basically told the judge, I'm not going to comply with you, period.
Yeah.
Oh, basically, no,
Did you read out that Teal versus Darby line?
The one, yeah, I'm trying to find it right now because
I've got it here. It says, so this is the part that Scotty Forbes Lee quoted. It is well settled that provisions relating to the setting aside of default judgments should be liberally construed so as to give litigants an opportunity to have the case disposed of on the merits, which I agree with. But the very next line, literally the very next line is, however, statutory provisions designed to protect plaintiffs from defendants who do not give reasonable attention to important business affairs, such as lawsuits, cannot be ignored.
Yeah, it's literally the next line. I have it right here. That's by the way, well crafted that she just took the that part out, saying, "Hey, you know what?
Dishonest. Yeah, absolutely dishonest."
I don't. Well, again, lawyer's going to lawyer, right? I'm not going to say that she's got a good reputation, and you know, she's got a lawyer. So this is what a lawyer does. A lawyer's paid a lawyer, okay? So I'm not going to fault her for this, but hey, my lawyer's a lawyer too, right? And my lawyer, you know, my lawyer pointed out a bunch of stuff. We pointed out, you know, we all read these things, and he says like this is complete nonsense because, again, the whole point is statutory provisions designed to protect the plaintiffs from defendants who not give reasonable attention to important business matters, such as lawsuits, cannot be ignored. Now, he has pointed out that Kyle has gone on air and just basically mocked the process. He's like, yeah, I got served. Who cares? And I waited till afterwards so I could just set it aside. It doesn't work that way.
And not including his attempts at defamation and like straight up attacks on the person that he's in litigation with.
Yeah,
Kyle is scared at the moment.
Oh, I have no doubt. He's acting out.
He was pretty scared.
Well, I find it really interesting that we're getting closer to an actual end of the nonsense that has been surrounding this case. Not too long after a different case, also involving YouTube, but this one crossing international borders, also got settled where
is conception, midget conception,
Sargon of Akkad, and that the woman that he parodied a video of hers, and she claimed both harassment and copyright infringement and lost resoundingly.
Yeah. Going Unicorn $5 continued. They hope that the whole case will be thrown out and Kyle will get to establish new facts like those fake invoices. Am I like, no one that stupid? Fuck shit. Yeah. No, I think you're right. But it doesn't work that way. Nothing of that gets thrown out like that. What it is this. He has found a group of people that at one time he thought were the most dishonest people in the world. Right? People that I, myself, Reds, Bullinator, Jared, Cheshire, and a host of other people, including Roof, do not find to be credible, do not want to be around. We distance ourselves from them. So what does he do when he is basically in a no-win situation? He has his back against the wall. He's been threatened by the judge to use up to incarceration. And he just all of a sudden ingratiates himself with an entire group. And they're backing him, going, yeah, you're really screwing Steve over, which he's not. What he's doing is he's screwing himself over, and we're sitting back going, hey, you know what? Keep giving him bad advice. I mean, the letter to the court was the greatest thing that ever happened to us. And I even told people the day before he submitted it, please, dear God, let him submit this. Please, dear God, do not talk him out of this. A couple questions here. Let's see. I saw a couple good questions in here. Steve, will you be claiming for the loss of revenue to the business after Kyle closed the channel? We are looking into various things. There's a possibility that we might hire an expert. Yeah,
that's a good idea.
And it is something worth exploring. It's one of those from the audience perspective. Don't worry about it because that is far enough down the road at this point. it's not a concern. At this point, the concern needs to be getting this motion addressed so things can go forward and getting the judgment addressed and enforced if by all rational analysis of this it holds.
Yeah. Now there is a potentiality of there could be some criminal matters at hand. That's definitely the case. What those will be or could be, we'll address those later on. As like my lawyer said with one of them, it's ripe.
I've said to a couple of people, there is actually a silver lining to having the service overturned. If I would like Kyle to be criminally charged with embezzlement.
Yeah,
right?
Me too.
If we put, like, as things stand,
I wasn't going to put that out there, but hey, since you did, whatever, man. But yeah, go for it.
I'm open with that.
Nothing to hide. I agree.
Yeah. So at the end of all this, right, assuming we win and everything, and let's say we win without officially hearing Kyle's side, ruled on in court. All right. So his facts basically not admitted. That makes it a little bit more difficult for a prosecutor to accept a case that is only half argued. If we lose service and the case is properly argued in court and a bunch of facts are established, that makes it a lot more easy to take a case to a criminal prosecutor.
That's exactly true. And here's the thing. Here's what people, for some reason, there's a BS narrative out there. Ask yourself this: do you really think that Ruhiff and I would have gone into litigation without having actual evidence of all this stuff? Does anybody actually think that we don't have multiple correspondences with Kyle on 50-50 from day one?
Do you think a judge would make a default decision based off of absolutely nothing? You think Steve and Ruhiff submitted zero things to the judge?
My lawyer he's seen the evidence. I mean, he has it. I mean, it's not like we make up the evidence, just because it hasn't been made public yet, which, by the way, I've given people my word it will be.
There's a lot of evidence that has been made public through either Kyle himself or through the court documents so far.
So let me ask you, Chesh, has Kyle produced any evidence that it wasn't 50-50?
I'm pretty sure there's Kyle on air debunking Kyle if Kyle tries to say it isn't.
Yeah, I mean, and by the way, that has already been ruled upon. That actually part of the default judgment. That's not even in contest right now. Like Ruhiff said, if it got overturned for some reason, we have to do it on the merits. I'm perfectly okay with that, because then we would involve criminal proceedings, I think. But like I said, there's a couple things I haven't shown publicly yet, but I'm allowed that. I will eventually. But like I said, I think Kyle knows what I have. He does the same things. So this narrative.
I think the one from the other day, I don't think he knows that exists.
Maybe not. He doesn't.
I don't think he knows that exists. I think that's.
But it doesn't matter
hilarious.
what he knows and what he doesn't know. It's a matter of I have it. And people have seen it. I don't just make this stuff up. But like I said, there's no reason right now to even question the 50-50. I mean, that's just a red herring. That's just people trying to distract from the fact that he was properly served. And by the way, I have something else that Intrigue Feline found. She's had a case where it says, and this is from North Carolina, that a copy of the summons and complaint filed in this action would deposited in the United States mail by certified mail, return receipt requested to the defendant, Alta D. Sandling, to her last known address. That the summons and complaint were in fact received as evidenced by the signed return receipt attached hereunto and incorporated herein by reference. And it goes on to say, it appears clear from the record before this court that the defendant was properly served both individually and executrix of the Sandling estate within the time prescribed by Rule 4. So anybody says that you can't be served at your last known address, you need to provide evidence for that, because I've actually found multiple indications.
What's the name of the case?
This was Sandling estate.
How do you spell it? Sandling.
Sandling, yeah.
Sandling estate.
Yeah, I just have an expert for it. Real quick though, in every case where they had service by publication that I found that talked about this, one of the conditions was, did they try to send a service to the last known address?
Oh, that's for service by publication.
Yeah. Yes, but my argument is, well, why would they bother to try to serve it to the last known address if that wasn't something that they do? Right. I mean,
that's a specific requirement of service by publication. And again, that was one of the cases that Scotty Forbes Lee brought up, in that they didn't, in one of these cases, they didn't send it to the last known address in the service by publication, and therefore it's defective. We do not have a defective service process.
Correct.
No, and that goes back to my question earlier of when you move, when you relocate your domicile that you are calling your house, your home, the two key places that everyone I've ever asked and come across you update your address with: the post office and your driver's license, your registration of your...
It doesn't even have to be their home. Matter of fact, in R.E. George, it actually says, quote, "It is unrealistic to interpret Rule 4 so that the person to be served only has one dwelling house or usual place of abode at which process may be left." Like you said, he got mail there.
That will be the case in this case as well. That will happen in this case.
Yeah.
Well, Steve, the reason why I asked that and bring that up is because when you update your address, especially with the post office, you have to check off to not notify your forwarding address to the people sending you mail. And that's why there's that requirement for the certified mail through the post office, because if you move and you let people know in the proper agencies that your new address is now this, anyone serving you a legal document through that process will get notified, and the service will get routed to your new address.
I think it gets bounced back.
It bounced back, and I think you get the forwarding address.
You get the forwarding address, then you got to resend it from there.
You resend it,
Yeah, they don't forward certified mail.
Why didn't Kyle change his address?
Well, here, like they are,
because his mother still accepts mail for him.
Exactly, and that's a usual place of abode. That's all that takes. And by the way, we even say defendant apparently contends that the service by certified mail must be at an address where he pays rent, receives mail, or reported to an employer to be his residence. Plaintiff cites no case law or statute supporting this requirement, because there is none. I mean, there is no requirement.
It has to just be a place that he gets mail at.
It just has to be a usual place of abode where somebody signed for it that can give him the papers, which happened. Again,
not even has to be a usual place of abode. Like, I wouldn't classify the workplace as a usual place of abode.
It's just a place that you regularly receive mail and can receive mail.
Yeah, I would have if it was a business where you receive mail.
That's a place you receive mail.
But all that matters is if he didn't receive papers. That's what the funniest thing.
And
if he didn't receive papers,
that's
it. If he didn't receive papers, then there might be some allegations that he could use. And by the way, it'd still be proper service because, again, he never rebutted anything, right? But
he would have to say that Kyle's mum and have some reason for saying Kyle's mother was not his agent. So, like on his stream the other day, he goes, what happens if me and my mother were estranged? And I'd be like, yeah, that's a great reason to rebut the presumption of service.
Well, I think that was a case like that where somebody's ex-wife got the papers.
That would be midget. I'll try not to say midget, but midget versus conception. And midget versus conception.
And he argued
this guy still had his address. He still owned the property. There was so much shit that the plaintiff brought that said he still lived there. But the fact is, he'd moved to the Philippines like 2 years ago, and the wife just didn't tell him about the lawsuit. And kept the papers, and that was ruled improper service because he didn't get the papers.
And that is the crux of it. And that really is the crux of it.
It is.
But that's a fair reason, right? If I had an estranged wife and they sent it to her, there wouldn't be an expectation of her giving me those papers, right? I mean, they're just at that point she's not an agent, right? But he didn't rebut the agency of his mom. Right, and I don't think that he could. I know that, and I think that Scotty recognized this, right? His lawyer said, hey, we can't really rebut this because, one, she was at the house, that you dwelled in. She did sign for it, which all that matters is the person is of age. He doesn't have to sign for it. Matter of fact, it even explicitly says that rule is the rule for service of the general statute 174.4 does not require the signing of the actual the person being served. It could be anybody that's of a suitable age. That's already been established. So she didn't try to rebuke that at all.
No, and that's incredibly telling that she didn't try.
Because I think she knew she could. There's just nothing she could. So she's putting all the eggs in the basket, saying, "Well, but he moved." But as my lawyer points out, so what? There's no legal standing for that to say that he moved. Okay, great. What law says, hey, this person moved, Therefore, if you got the papers, it should be reversed. There's no case law in North Carolina.
Yeah, everyone just says, everyone's response is just, he moved, therefore improper service.
Right.
The correct response is, I moved, and that is why I didn't get the papers.
That might be a little better response, but you still have to have a meritorious defense. You still have to say, I moved, I didn't get the papers because it got sent over here, and they just threw them away.
Yeah.
That might
or
be
I'm
a
estranged
case,
from my mother,
right?
or something like that. But
Yeah,
Scotty Closely did
yeah.
not make any attempt on the agent or the delivery of the papers.
Yeah.
And that's telling. That's incredibly telling.
But like I said, she's not going to lie for him.
or-
She's not going to say he didn't get the papers. That was
Valid.
conspicuous.
Yeah, that's probably it.
Yeah.
Yeah.
Right.
Yeah, because there's even before she got involved, it was already in the hands of who it needed to be. The admission from Kyle that he was aware of it, not just the quote of papers that I was served, but there's other recordings out there that he did acknowledge that yes, people are probably recording, and let them. I don't care.
The one with Hogtie is fantastic. Like acknowledging like what. So the answer paper, the response paper is not part of the electronic filings. So Kyle is sitting there describing the answer form, like, that's clear proof that he got the papers.
He got that in his hand, how to respond.
Yeah, and talking about how he's got to attach it when he responds, and it was hilarious.
So let me ask you two things. One, for having excusable neglect, he has no case for that. What is excusable neglect when you say, oh yeah, I got served, I got the papers, but I choose not to because I wasn't in correct headspace? That's not excusable neglect. Two, didn't he actually say that he did respond, and yet there was a technical problem then we looked at the court and found that there was nothing respond whatsoever? Was that an outright lie?
Yeah.
Oh,
and
okay.
the funny thing is, it doesn't matter that it's an outright lie, because it shows awareness of the proceedings, and talking about that he actually had the papers.
No, that's fine. It shows awareness to the court. I mean, the court already knows he got served. That's not even up.
Yeah, it's not an issue.
That is not. She didn't argue he didn't get the papers, right? So that's not in any relevancy. But in the court of public opinion, that Kyle's trying to spin all this bullshit, they forget to mention all the shit that he has lied about in the past, including that he already said he filed for something when he didn't at the time. He lied about having a lawyer, which he didn't. He lied about having a CPA, which he didn't. He lied about sending my videos to his lawyer, which he didn't. None of those things were true. And all of a sudden now, they're like, oh, well, Kyle's telling the truth now. And I'm going to tell people, this is how con men work. People had to say, hey, how do people believe this? Religious leaders, they do all this stuff wrong, and then they ask for forgiveness, and everybody believes them again, and they send them money. Well, there you go. You've watched it happen.
Oh, I forgot to read this last little bit. So when I said before, the language of the rule about certified mail makes no reference to home or office that is relevant here. It requires simply that a complaint sent by certified mail be addressed to the party to be served and delivered to the addressee. I forgot the final bit. They do not deny having received the copies of the complaint that were received by certified mail at their respective offices. The court finds that they were adequately served.
Womp womp.
Yeah, and same thing in Fender v. Denton. Defendant was served by certified mail at his law firm, and return receipt was signed by his wife, who was an employee of the law firm. Defendant did not deny that he received the summons complaint, but attempted to rebut the presumption of service by saying his wife was not authorized to accept service. The court found that the defendant failed to rebut the presumption of proper service. And by the way, she cites that very case.
Yeah, that's a bad case for Kyle. Really bad.
That's what I'm not understanding. Every case that she cited that I looked up doesn't help her, because
you know why they cited it though? Because they think our argument is improper service, but he got the papers anyway. That's what they think our argument is.
Okay, you've said that before, but where did that come from? Because that's the first I've heard that. Nobody's argued that our service was defective.
No.
Everyone argues that.
Nobody court-wise. I don't argue that because it wasn't defective.
Not court-wise. I have seen, going back to that court of public opinion, those voices that are cheering Kyle on, have a number of them have tried to characterize, oh, look, see, they're admitting that it was improper service.
Oh, really?
No, you
really?
dumbass.
No.
Yes.
No.
Yes.
No, dude, I'll go on record right now. Absolutely have I never said that was improper service. Matter of fact, I am absolutely convinced it's proper service. I mean, everything I've read, everything I've talked to my lawyer, before I was about 95%. I've even asked Ruev. We were going back and forth. What do we think? About 95%. I'm about 99.99% certain now.
I'm probably 90%. My only lingering doubt is that there is some unspoken or unwritten part of the law. So that in the presumption clause, it says, whoever signs for it is presumed to be an agent or is presumed to be a person of suitable age and discretion in the home. All right. So there's the agency part, which doesn't have the at home, and the person of suitable discretion at home. My concern is that there's some unwritten or untalked about qualification that if you attempt to deliver it to someone at what you think is their home, then that second half must apply. Whereas if you do it to a business or some other place, then the first half applies.
Well, let me rebut that. If there was any such law like that, she would have noted it.
Good point. Yeah.
I mean, because again, the judge knows the law too, and you can't just say, "Hey, look, there might be some unwritten law somewhere." No, you can only go by what we have available to us.
Or unwritten assumption in the judge's minds collectively.
Yeah, I don't think this guy's an idiot. But from what you've read, without going into what if some other weird law was out there, from what you've read, is there anything you've read that supports any evidence whatsoever to set aside to vacate the default judgment? Because I can't find anything.
Every time that they challenge the presumption of service, the key fact, and they say it in all the cases, they say, to rebut the presumption of service, you need to show that this person's not an agent and show that you didn't get papers.
That second part is the biggest thing. Once you get papers, it is how do you say that, hey, I got the papers, but this person wasn't an agent when they had to do the papers? That's all that matters. They had to do the papers.
Yeah, I mean, that's where you said like 10 minutes ago, where you said, if I delivered it to my mate's house and then the defendant just happened to come along to that person's house and get the papers, I would say that that's a reasonable argument to make that person was not your agent, even though you got the papers.
Yeah, and I even then, though, I think that I think it still would be proper service because you still have to have a meritorious defense.
It might be.
But at least it would be a better argument, right? Christopher Hogan for $5 says he is just playing games. It would not surprise me if his last act will be delete the channel and everything else, which, by the way, we've had contingency for. I will go on record to say if that happens, 99% chance he will go to jail.
Oh, absolutely, yes. Yeah. Yes, he will.
Yeah. We've already discussed that with the judge. The judge is very much aware of that. The judge will be issuing a warning to him at some point. I will tell you right now it's going to happen.
Yeah, if Kyle deletes the channel, he will be imprisoned. Yes, absolutely.
Yeah, it becomes a criminal matter for destroying business assets.
As to whether he goes to jail in this proceeding, I really think that's up to him. If he, let's say service is ruled upon in our favour and we go to a contempt hearing, I think if he has not turned over the stuff, everything, by that contempt hearing, I think he will go to jail.
Yeah, no, I think so too, but here's the thing. And I'm not going to go into detail on this. There's a lot of things that he has to turn over, and I don't think he's even aware of some of the things that we've asked for, and I don't think his lawyer is really aware either. And some of the things that we've asked for is not so easy just to go, oh, here it is. So if when he goes to the contempt hearing, he's going to have a hell of a time to turning some stuff over. I can guarantee it. So, yeah, I think he's, as OPT lawyer said, a lot of people play this game of chicken, thinking they're going to turn it over right before.
It's going to lose.
Yeah. So in that particular case, then, yeah, I think that he would definitely go to jail.
If he gets to a contempt hearing, I think he'll go to jail.
But here's also, I think that if he gives a contempt hearing, he probably won't show up and get a bench warrant because he's failed to show up to file.
Oh, yes.
There's a history of not showing up. Now, which, by the way, that becomes a huge different ball game at that point.
Yeah. That just makes matters even worse for him. Yeah. But actually, getting back to this, there's another question from the live chat that might actually speak to all this and kind of help alleviate and also enlighten some people out there. Mike Ortiz asked, if not for the coof, would this have already been adjudicated by now?
Yes.
Probably, yeah.
Probably. Oh, absolutely.
Yeah. In fact, that's what the lawyer points out.
How much of a troll is Unirock? Seriously, Unirock, biggest troll on the planet.
Well, here's the thing with like Unirock. We all know he's LARPing. We all know he's not. Yeah. He doesn't buy any of his own bullshit. But he's also taught Kyle how to LARP. Kyle has learned. I think Kyle
already knew. He was just given an opopportunity to be applauded and lauded for.
Oh yeah. Kyle loves his ego. When he has people going, "Oh, Kyle," and he thrives on this. So he's found a group of people that'll buy into his bullshit, that enjoy this type of nonsensical drama that he's fostering by all this bullshit that he's putting out there, and that's fine. Those are not the people that this video is going out to. those people have already decided that Kyle's the second coming of Christ and the Messiah, and that he's such a victim and all this. This video is not for them. This video is for the people that have watched this particular channel that know we have not lied to them about anything. That know his bullshit about, oh, well, Steve served him improperly and Steve knew it was a bad address, was bullshit. By the way, just to clarify on that, when I said that we knew it was an old address, I meant it was after the fact we had found out. I have papers going back to July 16th from our very first. One sec. Let me get this other. For our very first man letters, we did not find out that he moved until afterwards. Kyle didn't tell anybody. How would we have known? Were we psychic? I wasn't talking to Kyle. He didn't tell me that he moved. He didn't tell anybody he moved until like 3 weeks later, supposedly.
Just quickly, this current conversation is also not an admission that we think he moved.
Yeah. By the way, I have reservations about his move. I have, and by the way, that would be a limited discovery at some point. It needs to be. Right, because the way it would work is this: the judge. I can tell you right now, the judge is not going to override is not going to vacate it. What the judge would normally do in a situation like this, and this is from good authority, what a judge would normally do is say, I want a limited discovery, meaning that, okay, show where he's living, get the details of where he's living, where he's, at the time. He's not going to just believe Kyle that he was living there and set it aside. No judge is going to do that. No.
Well, there's also a misnomer in there to say that just because you're saying you knew it was an old address doesn't mean, one, you know what his new address is or what his current address is, even if that is a
well, that's true, but how would I have known that he moved? Nobody, he didn't tell me.
Well, and which leads to another thing, right? It leads to that you didn't say it wasn't his address, and even if it was an old address, without knowing the other one, it would still be the last known address anyway. Right. So the argument falls flat, and the question falls flat on its face right out the gate.
And by the way, I have all this correspondence to my lawyers. Nobody mentioned anything about last known address. That's where they sent it to him. They said, okay, this is his address where we can possibly serve him at, right? Because we know that he lives there. Whether he moved or not didn't matter.
Well, if he had moved and it got sent back, we would know that it wasn't
and then
his actual address.
And then we would send it to the next. We would have to. It's not forward.
Do some more detective work and actually find it.
That's Kyle et al. Trying to obfuscate, trying to get they're so trying to manipulate people to say, oh look, Steve started from the beginning fraudulently trying to serve it to a wrong address, which by the way nobody ever does. Do you think Roof and I would waste our time trying to serve it to a bad address? That's just absolutely inane.
You have to jump through 3 hoops to even get to that first starting point of Steve knew that it was not Kyle's address, which, 1, isn't what you said, and 2 is implying an intent for a court case that you're suing somebody else in, so that doesn't make any sense.
Why would we do that?
Yeah, you can't plan on a default judgment. That was furthest thing from my mind.
Good quote. You can't plan on a default judgment.
Yeah, of course, that's ridiculous. And by the way, did you guys notice he didn't breathe that? He didn't argue that to the judge. Hello, if I did something that was unethical, if I did something to try to manipulate the court system, which he's trying to convince people left and right, Steve, served it to an old address, willfully trying to manipulate things. Why would you not tell the judge that?
Yeah.
Because it's bullshit. Yeah. There's a court of public opinion that he's manipulating, and then there's the actual court case. We've been telling you from day one the actual truth of the court case, and we're going to continue to. He has not.
Like Steve mentioned a minute ago about the original demand letter. That demand letter says, "Dear Kyle, we're sending this to your email address, and we are also sending it to 1532 Providence Church Road, Pleasant Garden, whatever it's called."
Yes.
Kyle obviously got that.
Yeah, he got the demand letter.
Second.
He got the demand letter.
I said, boxed. No.
Yeah.
What'd you do?
Well,
he's had ample opportunity to say this is not my address.
Yeah. And that's what I'm saying. It goes back. The demand letter was dated July 16th.
16th July.
Yeah. Well, and something with the email that actually came to mind for me that would have been nice, just again, a little bit of CYA, a little bit of cover your ass from this side of it. If your lawyer was using, especially Outlook, you can do it really easy. set it so there was a read receipt, so you could actually get the
Yeah, good idea.
notification when he opened the email.
Oh, there's
So-
there. I can tell you this. There's a lot of stuff that we're going to be
Oh,
moving for.
fucking great.
Yeah, I mean,
Love
like I
it.
said, my lawyer has basically told me this. He knows that we go on air. He knows we talk about this stuff. There's certain guidelines that he's giving me just out of, he's a lawyer. That's what he's supposed to do. A lawyer can't force anybody to do anything. They just advise. In fact, this is what I asked him. I asked him very specifically, how come Kyle's lawyer, I said, isn't Kyle's lawyer have to be, concerned? And he's like, yeah, absolutely concerned. Okay. That kind of correspondence, no big deal. But what we plan to do after his motion to get set aside is rejected and denied, we're not going to go. I'm not going to go into any of that. Now, why would I? Right? That stuff I'm just going to not even discuss. But we have stuff. I mean, we have. I don't know why anybody thinks that we just go half-ass with this. I mean, do you think Rube would waste his time with a half-ass case?
See, and I think that is arguably the quintessential starting point. And during the argument, when Kyle said, "So sue me."
So sue me.
Yeah, and we did. Now, granted, I mean, a lot of people are like, "Well, Steve, you said that it was a verbal thing, and you couldn't sue him." Well, again, I was a little bit taken aback that he was going to be that obstinate, right? But I was like, okay, I know that I have some legal standing here, but how am I going to sue him? I didn't have the resources. Luckily, Rube stepped in because he wanted to see justice done.
Well,
but
that was banking on, right? Kyle was banking on that you wouldn't be able to do it because he took all the money.
But here's the thing: Ruhif has seen the evidence. Do you think Ruhif would have taken on a case if he said, "Hey, Steve, you got no evidence? Why am I going to back this?" I mean, seriously.
Yeah, I'm pretty sure he would have been like, "Sorry, bud, screwed yourself.
Yeah.
You played yourself."
And for a verbal contract, even my lawyer said the first one, he went to a different company, but he basically said verbal handshakes are done all the time. All you need is some kind of correspondence to kind of back it up. That's called a handshake deal.
And actions that reinforce the verbal agreement.
Right.
So you guys,
we have
co-hosting a show for fucking 80 months or whatever.
Him wanted to change the agreement from 50-50 to something else.
Yeah.
That's a tacit admission that it was 50-50 to begin with.
And I also have email correspondence.
There are so many. I mean, the court of public opinion is kind of saying, Kyle said all this shit that's damaging to him, and Steve said all this shit that's damaging to Steve. Utter bullshit. That is so the balance is so lopsided on that.
Yeah,
Kyle
I haven't said anything. What's funny is it's worked out to my advantage because what Kyle did submit before he had his lawyer could tell him don't do this. He submitted, that bullshit transcript of taking things out of context about me, improperly serving him or whatever. That didn't do him any favors at all.
It showed him to be petty.
It showed him to be dishonest. Super chat, $2.
Super chat. Shift Advant. What if you lose? Will you continue? Yes, I'm committed to seeing this through until the end of this case, up to the point where we hopefully file a criminal complaint.
And
my question is,
and my lawyer knows this as well. He very much knows our intent. What?
Well, what do they mean? Lose what? Like right
the
now,
whole case.
You're not fighting for anything that can be lost in this current, in the current two things.
That's true,
right?
but
if you lose the service,
if you lose the service, the
then
contempt
yes,
goes away.
obviously we go through with the trial again.
If you consider that losing, it's more like just sort of we're going to reset the playing field a little bit, but nothing changes. So
the contempt goes away because he's only in contempt because of the default judgment. If the default judgment was set aside, he couldn't be held in contempt, which sucks, but that's the way it works.
I have to run.
Hi, buddy.
Thank you for letting me in, Steve.
Yeah,
I'll catch you guys.
Yeah, we're going to wrap this up.
Fair enough.
A few more minutes,
all right, cool.
Because I know we got Veterans Week with Talk Weekly with Jared here, so we're running a little bit late. Jared, can you get about another 5 more minutes to wrap up?
All right, I'm going to go catch you later.
Yeah, we got time. I didn't set it to go live until about 9:45, so.
Oh, okay, so we got a few more minutes.
Yeah, we got until the half hour, another 20 minutes.
Set it up so you can throw the link. Put the link in the live chat so you can set it up. So,
well, I can't because I'm not a mod.
I can make you mod for a minute. I'll just make you a permanent mod. It's okay. Unless Cheshire has some objections.
No, it's all good.
She's like, you don't want to give him mods. No, what he'll do with it? He'll go nuts. He'll start deleting people. Oh wait, I can behave. Sure, you can. All right, I try.
Why would I ever want to take any power away from my boo?
AT has definitely proved himself to be honest over the years. No question about it. You have integrity. I admire that. Let's see. But if you lose, so here, what Chester's talking about, like, what overall can we lose? I mean, when somebody fraudulently takes $60,000 and doesn't pay somebody, you can't just get away with that. Okay. There was something that we initially filed. It was called unjust enrichment. There was 7 counts that we put things under, and the unjust enrichment is a catch-all. That's the only one we didn't. The judge didn't side with, because that's good. We didn't want him to side with that one, unless it was everything's failed. Then it's unjust enrichment. But since he found there was fraud, fraudulent conversion, unfair and deceptive trade practices, breach of fiduciary duty, and breach of contract, those take precedence. You don't need the unjust enrichment. So we would just go back and say, look, we've already been established that these financials are fraudulent. It's already been established that he agreed to 50-50. It's already agreed that he had at least 60,000. It's already agreed that he's not submitted proper books to the court, as we've asked. All that's still out there. So there's no possible way we could lose on that end. He still owes money. Matter of fact, I have very few people that are out there going, oh, well, he doesn't owe you any money. Well, okay, who thinks he doesn't owe me money? And so what is he even fighting for at this point? It's just because he is stubborn, that he thinks he's hurting me. But at the same time, I'm telling you here and now, he's the kind of person to cut off his nose to spite his face, when this is actually doing far greater damage to him than it is to me. He's literally looking at jail time right now. I'm not. There's nothing at all. The judge has told him he could use up to incarceration to comply with the court order. He's not talking about me. He's talking about Kyle. Paul says, have you taken... No, I'm not going to read that. Let's see here. Dr. Zaya says, I'm very confident Steve will win the whole thing, but regardless of what happens in court, Kyle jacking the channel will always remain a massive scumbag move. Of course. Yeah, I mean...
That's the thing. Yeah. That even if Steve was to lose and Kyle was to win for some overturn, I actually had Jimmy Snow, Mr. Atheist, ask me this question when I first showed up in those chats, because he was like, oh, look out for that Steve guy. And I was like, I mean, okay, but here's the thing. Because he was like, well, what if you're wrong? What if Steve is wrong and he's lying to you and blah, blah, blah. And I was like, I mean, fine, but morally, either way, Kyle's still in the wrong for how he handled this. End of story. There is no coming back from that.
Did not Mr. Atheist find out that Kyle was lying to him? And even said...
Yeah, he also told the Non Sequitur Show fans to go fuck themselves and everybody else to go fuck themselves, and to the point where he was trying to hide the information from people because, Kyle was still streaming on his show while he was streaming.
Yeah, so Kyle lied to every co-host, and every co-host that he brought in said that he lied to them, that they trusted him and he screwed them over, and now he has new co-hosts out there doing other stuff, and they don't see a history. And I'm thinking, okay, you do you, boo. Whatever, it doesn't bother me. I'm like, I don't care. It's again, if people want to believe somebody, hey, knock yourself out. Beliefs are beliefs. But when you have a history of somebody who's continually lied from day one, that has not been honest about anything, and you're sitting there going to tell me that, oh, what if Steve lied to you? Okay, well, here's the thing. What have I lied to you about, Chesh?
Nothing I can think of up without the top of my head.
She'll have to make some stuff. So see what she does. She'll make it up as she goes along. But yeah, but Jimmy knew.
She does it. It's at least entertaining.
Yeah, but see, Jimmy knew. Jimmy knew that he got a cease and desist. Jimmy knew that I had written him saying, look, if you believe Kyle, why don't you be the skeptic that you pretend to be and ask him, where's the funds? Where's the money? But he didn't want to do any of that. And then Kyle saying, well, yeah, I have the money, Steve. Okay, great. Where is it? And oh, well, Steve didn't want the money. Bullshit. That's not what I ever said. I mean, from day one, all I wanted to do was verify that we had some kind of accounting for it, that the taxes were done properly. But he never had any of that. And yet he said, oh, I have the money. Now it's like, I don't have the money. And people still give him $5,000 for a GoFundMe to get a lawyer. But by the way, thank you for that. That helped us tremendously. And by the way, to go to trial, whoever asked, if it got dismissed, if you hire a lawyer on a fixed retainer, it's only to do a certain job, and in this particular case, it's to represent the defendant for the contempt hearing and the motion set aside. If it was to go to trial, you now have to come up with another retainer. A trial retainer costs about $25,000 minimum, and she's probably a little bit higher for her particular group, from what I understand. I was told they're a very high priced lawyer, but it'd be probably about $25,000 retainer. The $5,000 retainer doesn't cover trial if it was to go to trial. So, shift $5. If Kyle wins the service, he is looking at jail time. Is Kyle still legally guilty if service is thrown out, or is the order no more? If the service was vacated, there's nothing to have contempt on. But the lawyer, the judge is not going to automatically forget of the problem. We're going to ask for a summary judgment, and then he would order it, and then Kyle would have to comply to that. Probably is what I'm thinking.
Because to date, Kyle has not provided anything of substance to even potentially sway the order away from your side of things, Steve.
Nothing.
And that's
it's all he's doing right now is he's placating to the court of a public opinion for those sycophants that want to believe him, or they just don't care one way or another. I'm on record. I think they're just trolling him. I think that almost everybody that's out there talking to Kyle is trolling the shit out of him, except for a handful of people that actually do buy into his bullshit. But most of them, they don't care about him. They would love to see him go to jail. And he's playing right into it because it feeds into his narcissism. And then he has the audacity to try to say that I'm like a narcissist. I'm like, I don't think he knows what that word means. I'm not the one that was like, oh, I can't mess up my hair because, I can't wear earbuds. We create an echo because it might mess up my hair. That's a little bit of vanity there, I'm sitting here. I haven't even done my hair today, and I'm in glasses. I don't give a shit.
And
I'm not here to turn you on, Jared.
When you go into that and the mindset and the mentality that is being displayed, there was that screenshot that you even showed it to me, Steve. I had other people show it to me from a particular Discord server where, Kyle, I know you're going to end up watching this if you're not already watching this. You really need to be careful about the words that you choose to use. I say that from experience.
Thus says, can I ask a serious question? Would you have still proceeded with legal proceedings without an outside backer? Probably, but I would have been funded differently.
Yeah, at this point, it wasn't whether or not it was going to be brought to court. The question at that point would have been when. Yeah,
exactly. Zaya says, Kyle is claiming that he desperately tried to pay you, Steve, but Steve would only take money and untraceable gold Kirkerans in a duffel bag. It's totally fucking absurd. Oh, great. Why doesn't Kyle produce over those things? Why didn't he give that to the court? There's not a single instance of Kyle ever trying to give me the money. Not one. If he had it, where is it? Because it doesn't exist. What he said was, I will pay you. We will get paid after April 15th, after tax day. Tax day came along on April 16th. I messaged him, what's going on? Where's the money? And he's like, oh, my CPA has all that. We'll get to it. Could still, for days and weeks, turns on end. I couldn't get anything out of him. Then he wouldn't talk to me. And then I messaged Bull and I messaged Reds and say, hey, what's going on with this? Who's this CPA guy? Where's the books? Where's the money? What the hell is going on here? Right? I mean, where did you think that he had? If I was desperately trying to pay me, why did the CPA contact me that he said he had? Oh wait, because he didn't have one. How could he be paying me from somebody who didn't exist?
Wait, Steve. It's even more simple than that. If he was desperately trying to pay you, why were you the one going after him about it?
I don't know. That's what I'm saying. I mean, I have my correspondence with him that says, right. where's what's going on here? Have you talked to your tax guy? I couldn't get anything out of him. And then we were talking a lot of it on, before shows, and I couldn't get anything out of him. Finally, Reds is the one that finally said, Steve, you've got to have this discussion with him. You can't just it's been 2 months now since April 15th, and you've just been postponing it. And I don't like confrontation either. And I also knew, and I even told Reds this, that if we have this discussion, non sequitur is probably going to be over, because I know Kyle, and Kyle was going to be just, I figured he was not going to be honest at that point. because he didn't want to be confronted about where's the money, where's the books. And you saw from the death of non sequitur show how dishonest he was being. Oh, well, I'm changing the terms of the contract. You can't do that, right? And then he says, "Oh, Steve's going to get paid every dollar owed him." Really? So why did you submit something that's saying that I somehow owed him money? But by the way, courts don't work that way. When I'm suing, he can't get a dime out of it. That anybody who thinks otherwise doesn't understand the legal system. Shift for $2. What evidence did you give the court? Statement only? No, I have actually given copies of my emails to my lawyer.
Yeah, the actual correspondence which laid out, which corroborates the additional affidavit, which is the claim that was filed, which the court evaluated and deemed, yes, this is a business issue. Yes, this needs to be in business court. Yes. And that's where it has been.
That was actually, you know what's funny is that was actually, if you look at the very first thing that was done, it was actually this North Carolina Supreme Court judge. I think his name was Bledsoe. My lawyers went to the Supreme Court, explained the situation, showed him the things, and said, we need to have this in mandatory complex business court. He agreed. Okay, yeah. So that we went out. That cost an extra, I think, $1,000 up front to do that. But that's what we wanted. The reclusive extrovert became a Benegator's layer. Thank you, reclusive extrovert. A new member. But like I said, I promised people that I would be transparent. I promised people that, I would explain to people what's going on. And I've done that. I literally have told people, if you want additional evidence, come to me. I'll show you. Kyle has never done that. Everything Kyle has said has not been backed up by anything. Like, nothing. Where's all this evidence that he's trying to give me money? Where's all this evidence that he had a CPA, which he didn't have?
And reclusive extrovert just upgraded on top of it.
Oh, the curious follow. Thank you, reclusive. I'm not sure I know the name, though, but I appreciate it.
So, with that whole claim of attempted payment and everything, I remember when that happened because there was an adjacent conversation that I was having with a particular person who is not, but not on Kyle's side of it anymore, where I put it to her to take the same business deal that she was saying you should take from Kyle, but I'm in the position of Kyle where, yeah, I'll pay you. You know what? I'll even pay you more. I'll pay you 80% of the profits, but you don't get to see the books. Do you still want to make the deal?
I want to see the books.
And she blocked me.
Yeah, I want to see the books. Yeah. Shift asked, I asked what evidence you gave the court on your lawyer. We gave it to the business court. We gave it to the initial North Carolina Supreme Court. I don't know what my lawyer showed them. I have no idea. All that was done closed doors. But if you look, we actually have a letter from the North Carolina Supreme Court designating it as a business court. So I don't know what he gave to them. So I don't know what else to answer that question. Min says $5. I wanted to believe Kyle, but evidence is against him. If he could not even convince a loyal patron like myself, who could persuade him? By the way, Min was probably one of his most loyal. He was like one of his lone holdouts. And, he had told me, look, I'm a Patreon to you and I'm a Patreon to Kyle. And I told him, fine. I'm like, dude, you do you. I never told anybody to stop being a Patreon to Kyle. Not one person. And Min there was one of his most loyal supporters until the very end when he started asking Kyle for evidence and wasn't getting anything. Ask me for evidence. I'll spend an hour with you going over the stuff. But nothing Kyle has ever said was true. Nothing.
It's amazing how receptive you are to these questions, Steve, when someone comes in actually asking questions instead of making accusations.
Honest intent is everything, right? You ask me questions with honest intent, I'll answer with honest intent. I don't like being sea-lined. This person doesn't seem like they're sea-lining. So upgraded membership to Curious Follower. Moon. Thank you, Moon. Hope I was well with you, by the way. You've been a busy person. Reclusive Extrovert says a longtime follower with a new user. Thank you. And like I said, we don't do these very often. Again, I don't like doing these types of episodes. The only reason why I'm doing this today is because we had two people go on air recently, and they just butchered these things, and they just basically ran such nonsense. And dishonestly, I think, looked at these court cases and tried to make it appear that my lawyers motion was not as airtight that it actually I think it is, because none of them actually cited the cases correctly. And again, I still challenge people, find one court case where the person got the papers that it was overturned because they weren't living there. Name one. That's all you got to do. None of them exist, or at least I can't find any. My lawyer can't find any. His lawyer can't find any. Schiff said, and you proved it to the court. I'm asking what evidence did you use? I just explained that. My lawyer has the copy of the email evidences showing that was a business partnership, including the DBA that didn't get filed, but there's intent there. His correspondence with me talking about 50-50 with Kyle from day one. Me talking about when Kyle started getting other people to come to the show to do co-hosting, I specifically asked him, you didn't promise them any percentage because I want to make sure it's still 50-50. He said, yeah, I didn't promise him anything. I have all these things over and over again. Him thanking me, saying, congratulations, partner, once we got established. He saying that he wanted to have 50-50 partnership. I have all this stuff in email. That's all given to my lawyer. Again, what did Kyle show? I mean, Kyle's literally the one that said on air, well, it wasn't on air, but in a video, that, yeah, it was 50-50, but he's changing that agreement. So, what other questions we got before we turn it over? Anything else, Jared? Do you want to go, Chush?
No, that's everything for me. I don't got nothing.
Yeah, no, and pretty well summed it up. I mean, even where was the comment before? I should have highlighted it. Miss it now. Where there was the comment in the live chat, and this it's frustrating because when I've been a part of a number of businesses from a managerial and an operational side of things, there's a certain way you act with a partner, even if you are a minority partner or the majority partner of a business arrangement, there's certain decorum you keep with the person in the business setting, even if you absolutely fucking hate them personally, because there are legal ramifications if you do it wrong. And some people are finally starting to see that play out in front of their eyes.
But do you agree that probably the vast majority that are on Kyle's side, most of them are trolling him? Or a lot of them?
I suspect a good number of them are,
yeah.
or they're just maybe not to troll him, but more get their jollies off in their own twisted sort of way. But
I mean, I understand the court of public opinion. That's why I do these transparencies. But the reality is Kyle's not going to put one over on this judge. I want people to go read the case. I want people to go see for themselves that his lawyer never actually articulates any grounded reason legally why it should be dismissed. I mean, she cites cases, but if you go read the cases, none of them apply.
They half apply, and that's the problem. Is it's like, okay, you can see where you're going, except there's a common thread here missing. The common thread, all the cases that Kyle's lawyer submitted with the amendment, all of them, the defendant was not served the papers. They had no knowledge. Where is the demonstration that Kyle had no knowledge?
Yeah, well, that's the problem. I mean, it was all the cases where that the person didn't get served the papers. They didn't receive notification.
Yeah.
That's not the case here. He received notifications. So any kind of technical thing, which by the way doesn't exist, would be just that. He would have to still have some kind of meritorious defense. He can't just say, "Hey, I got papers. I was aware of it, but I didn't. You know, my mom signed for it." Who cares? That's irrelevant. That's enough. His mom can sign for it.
And over about hearsay, but they're just taking Kyle's word, which would be nothing but hearsay. So, these are the same people who also just straight up jumped on, oh my God, this Steve owes Kyle so much money based on nothing.
And by the way, there's two courts involved, Advent and God's Auditor. You're confused here, I think. There's two courts. There's the court that Judge Gale is part of. Then there was the initial court, which was the North Carolina Supreme Court, that we had to get a specific letter from designating it as a mandatory complex business court. That was through Judge Bledsoe, I believe his name was, wasn't it? That's the court that I'm talking about. That's the court that he gave stuff to, I'm sure. But again, I don't know what. So there's two different courts. There's the Supreme Court, and then there's the trial court, the business court. Yeah. Does that make sense? I mean, I can show you guys the letter. Have you guys seen the letter?
The recent one or the...
No, the original notice of designation through the Supreme Court.
I took a look at it a while ago because either I got it directly from you or it was one of, if not part of, the first docket filing in the database. I forget which place I saw it, but I do recall seeing it.
Give me a second here. I can bring it up for you guys. Just talk for a second while I do this.
I will reiterate this, and this will be fifth time that I've said this. In the entire situation, there is the other narrative out there that a certain someone can't take criticism at all. My stance from day one, and again, here I am right in front of Steve saying this. Yeah, Steve, you have some of the blame in this. You were an idiot at some points in what led up to all of the nonsense. But Steve being an idiot does not justify or make what Kyle did acceptable.
Yeah,
You know, that sounds-
a little pushback on that. It's not so much I think I was an idiot. I was very trusting. I trusted Kyle. And I even said that in my emails, even to Rez and Bullinator. I trust Kyle on this, that he's not going to screw me over. So was I an idiot for trusting him? Okay, you can make the argument for that. But, you know,
That's why I say you were an idiot in this.
You're kind of losing the point, though, right? Because you don't tell somebody that, oh, you know, they deserve to be attacked because of what they were wearing. Somebody doesn't deserve to get hit by it with a bat because they're stupid.
Well,
it still counts as assault. Still counts as assault.
So let me show you this. This is the Office of the Chief Justice of the Supreme Court of North Carolina order. This was dated, let's see here, 8/26/2019. This is to the Honorable...
I feel like by a bat.
Judge Craig, one of the senior resident judges of the Supreme Court of North Carolina, greeting as Chief Justice of the Supreme Court of North Carolina by virtue of authority vested in me by the Constitution of North Carolina, in accordance with the laws of North Carolina, rules of the Supreme Court, and specifically North Carolina general statutes, whatever. I here designate above reference as a mandatory complex business. I hereby order the Honorable Louis A. Bledsoe the third Chief Business Court Judge to assign a case to a specific business court judge, which he did to Judge Gale, who is hereby commissioned to assign such session to the court as may be set to enter orders and attend in such chambers matters, etc., etc. Actually, this was actually August 23rd, 2029. That's when the letter was actually signed, August 23rd. So literally, at the very, very beginning is one of the first things that we had happen. My lawyer had to go to the Chief Justice of the Supreme Court and explain to them the court case. And I don't know what he showed them. He had basically a bunch of stuff that I sent him, but that's the court that I'm talking about. Does that make sense now? Right? It was the Supreme Court that he had to show something to. We on the same page here? We good?
It should
I disagree with all this. Steve is going to lose and go to jail.
There's always got to be one.
Well,
in the
here's the
crowd.
thing: people are gonna LARP. People are gonna spin.
That way, because you know what that means?
What's that?
That means that all of the Unirock fans and all of the guys that you guys dealt with before, it means that they agree with me if I'm right.
Which is what?
I see what you're doing.
I'm confused. Why is Cheshire right? I'm confused. What about?
Oh, Steve, sweet summer child.
I know.
Steve, we'll explain it to you off air, and we are actually about that time. We can go ahead. So, for everyone who doesn't know, let me actually make sure the link is still on my clipboard. Yep, it is. So, the link I just posted in the live chat is the next event over on my channel, which will start about 10 minutes after we go off air here. where the conversation will continue, and who knows where the hell it'll devolve into this week. For some reason, I think it's going to end up being a bit of food porn, judging by Twitter the other
And
day.
go subscribe to him too.
Exclusive extrovert said Unirock will be a pioneer for hashtag free Kyle. If he starts an organization to try and help people get representation while they're in jail, whatever their crime is, does that make him an apologist for whatever that crime is?
Right. Ash Scott says there are no Unirock fans, only people who can't find anything to watch that late at night. That's good. Like I said, look, Unirock's going to spin. I don't talk about Unirock on my channel because he's irrelevant. I don't care. He has this weird obsession with me. Let him. It's done nothing to harm me. Basically, it's showing people the guy's just not mentally there, and I think he's mentally unwell. And you know my policy. I don't deal with people that are mentally unwell because I think it's unethical when people have that kind of mental issues, and I think something's not right upstairs with him. But if you guys want to, go nuts. I mean, I know AT2 does. I mean, he loves to talk about Unirock. Be my guest. But we all know that Unirock lies. We all know Unirock doesn't get shit for Shinola correct. And he just plays these games like, oh, I talked to the judge. Okay.
But wait, does pointing and laughing constitute as talking about?
Yeah, I guess so. Yeah, why not? But like I said, he's screwing Kyle over hard. I mean, Unirock's one of my besties at this point for what he's done to help me out. I mean, seriously, my God. He's trolling Kyle so hard, it's ridiculous.
All those people so I could get Kyle to come forward and say all this shit that was completely unnecessary and not needed.
Schiff says, did you give any evidence to get to default judgment? Did you prove Kyle guilty with evidence? You don't need that for default judgment. It's there, it's available. It's called discovery. We were all ready to go to discovery, but we didn't, as Auditor pointed out, we didn't go to discovery. So that evidence is sitting there ready to go, but we got the default judgment instead. And that, by the way, is proving him liable, not guilty. The word's liable in a court. If he doesn't show and we get a default judgment, that means he has tacitly admitted to everything that we've complained. That's what it means in the eyes of law. Go ask a lawyer.
We should sign out.
Yeah.
And I got something
this is what we were for saying. If we ever had to start from the beginning and we had to go by the evidence, we would take a different route and go with embezzlement. We'd go more of a criminality to it. But anyways, go ahead, Shush.
But again, we can get into this more here shortly over on my channel.
Yep.
Like I said, conversation's going to continue there, except don't be surprised, people, if the topic ends up veering off, which will be determined by who's on the panel and how the chat's going. But we will start out there. So if you want more of these questions answered, come bring them on.
Yeah, and I probably won't be having anything to address until after. I think it's 2 weeks. We pretty much 2 weeks probably before we hear something. Again, I don't like doing these that much, but I do have an obligation to you guys because I told you I'd be transparent. But we got Caffeine Corners on Monday, 11 o'clock, Cheshire. We got Over and Under at 8 p.m. with Chris Attlee. We've got Rum and Cokes on Saturdays. I got the Controversies on Fridays. I'm going to be doing something with Cheshire? What's his name? John something or other, the guy from Atheist Alliance.
Yeah, we also got a guy potentially coming on to talk about different platforming and what works and what doesn't. Puck, can you please stop for like 30 seconds? I'm coming. Yeah, relax.
So we've got a lot of stuff planned.
That time of the month is going to be on Sunday at 9:45 this Sunday coming up because we moved it for the for Red's stream. So before you guys head off to your other stream, somebody tweeted out, "You want socialized medicine? Tell me again how good Canadian healthcare is. Tell me about the wait for your serious medical procedures. Did you guys learn anything from the complete failure of Obamacare?" Response: My husband needed brain surgery. World-class neurosurgeons removed a wedge of his skull, used lasers to remove scar tissue on his temporal lobe, and then put his skull back together. My biggest expense were parking and snacks for stress eating. Yeah,
no, I mean, Canadians have it pretty good.
Steve, you're supposed to take the conversation to the other stream.
Oh, there you go.
I'm giving you a hanger.
All right, there you go. Take it to the other stream. Go subscribe to Jared and go finish talking to him over there on Veterans Talk Weekly. Thanks for watching, guys. Leave a comment. And again, If you have a case, cite it. I'm not going to deal with people that don't cite cases. I had that on Red's channel. This idiot was just like, hey, Steve, you're wrong. Okay, cite a case. Couldn't do it. If you don't have any legal citations and something we can look at, don't bother. But if you do, knock yourself out. Okay, sound good? Good night.